everybody. Welcome to another edition of POL 305. Now that we've moved into the sort of substantive portion of the course where we're talking about research, we're going to start talking about some of the ways that it's theorized that judges behave. And the first one we're going to start with is the legal model. There's a couple of other ones that we'll get through over the next couple of lectures, but the legal model is sort of this old school, this is what you kind of get in law school type understanding of how judges and justices in the federal judiciary behave. So, what I want to achieve today is to, well, tell you about the legal model and how some people theorize judges make decisions. Um, I want you to, at least for the first portion here, set aside what we know about unconscious biases. You're sort of required to do that if you want to believe the legal model. You can tell from the way I'm kind of talking about it that I don't buy the legal model. I kind of doubt many of you will after this conversation either. But at least for the first part, let's set aside what I've told you before about the way justices use ideology and the way that humans think and sort of have these unconscious biases. Okay, so let's start with me telling you what I mean by model. So we're going to talk about the legal model, and the next lesson, the attitudinal model, and also the strategic and psychological models. What do I mean when I say model? Well, it's a conceptual model, right? It is a way to conceive of the way something in the world operates. Okay, it is a representation of reality. I'm not saying, and nobody who talks about models are saying, I've captured reality and here it is. It's a mere representation of the way we think the world works, the way we think reality works, or what reality is. Reality is made up of the systematic and the stochastic. That is the things that happen sort of regularly that we can see happen and that we know they're going to happen. And then the stochastic, which is effectively the random. What a model does is it tries to capture the explanatory aspects of some activity. That is, it tries to capture the systematic component of reality. And it has to ignore the aspects that don't reveal much. That is the stochastic. Now, one tough thing about models is that we cannot know, it's impossible to know what portion of reality is made up of systematic and what portion is made up of stochastic. So it would be wonderful if reality was 100% systematic, but it just doesn't work that way. There are two objectives of a model. The first is to explain the behavior in question. So here we're modeling judicial decision making. We can really only explain the systematic components. So the goal of a model is to explain systematic judicial decisions, how judges come to those decisions. And the second is to do so parsimoniously. And what I mean by parsimony is to do so simply. Um, if we were to take every single thing about every judge that's ever lived, including trivial things like their height, their weight, how many brothers and sisters they had, all these various things, and threw them into some model of reality, we could probably explain everything. But we wouldn't be able to figure out what does what's actually working in a meaningful way. So parsimony is explaining things simply, though sort of simply but thoroughly. Okay, so a parsimonious model isn't one that only has one explanatory variable. That may be too parsimonious. So parsimony means simplicity with being thorough. Okay. Another way to say parsimony is a small number of factors common to the observed phenomena. So what are we looking at? We're looking at the way judges behave. What are the factors that are common to that behavior? Okay. A good model should predict the future. So if we have a good idea of how judges behave and what influences their behavior, we should be able to figure out what they do in a vote down the road. And in fact, that's one of your main tasks in this course. That's what your papers are about. You're going to take the information that we discuss here in these lecture slides and the notes and YouTube videos, and you're going to predict what happens in a real life Supreme Court case. And the reason you're going to be able to do that, or should be able to do that, is because good models are good at predicting the future, not with 100% accuracy. There's still a stochastic element to reality. But if you know some of the systematic features of the world, you should be able to take those and bring them to bear on as of yet haven't happened outcomes. Okay, so that's what a model is. So over the next couple of lessons, keep this in mind when we're talking about the various models that try to explain judicial decision making. So the role of judges in the legal model is to simply decide cases based on the facts of the case, the relevant law, right? That relevant law might be the Constitution. It could be a statute passed by Congress or by a state. Could be some action of a bureaucratic agency. But the goal, or rather the role of judges in this model, is to simply take those things and decide. The legal model emphasizes what's called mechanical jurisprudence, right? And it's sort of taking these inputs, inserting them into the judge like they were a computer, and then their brain is supposed to go boop, 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 processing the law and then spit out an answer. So mechanical jurisprudence is this idea that you could take 100 judges, give them the same information, and they should come to the same decisions because there's a right and wrong answer when it comes to the law, according to the legal model. This is where you need to set aside what we know about implicit biases, because mechanical jurisprudence assumes that judges are capable of impartiality when we know that nobody's capable of impartiality. It's very, very difficult because we're perceiving the world differently than somebody next to us. But again, for today, let's assume, at least for a little bit here, at least for the first half of this or whatever, that judges are indeed 100% impartial. So this mechanical jurisprudence thing exists. 100 judges should be able to come to the same conclusions. But we know they don't. Anyhow, the question is, what shapes decisions then? If judges are supposed to be 100% impartial, and they indeed are capable of that, they're capable of mechanical jurisprudence, then what ends up leading to disagreements in the judiciary? Generally speaking, the legal model asserts three things end up shaping judicial decisions. The first is the language of the applicable law. That might be the Constitution, a congressional statute, what have you. The second thing is the intentions or motivations of those who made the law, right? This kind of lines up closely with what we talked about a couple of lessons ago with originalism. And third is precedents established in previously decided cases. That is, what have previous courts argued about similar cases? Okay, because they do, or at least they're supposed to have some binding force in American jurisprudence. The thing about these characteristics, though, is that they're pretty concrete. They're immutable. They can't, there's a right and wrong to them, it seems. And that's pretty problematic when it comes to judicial decision making. Because if those things are concrete, if they're immutable, how are there disagreements? If there's a right and a wrong, how do people come to different conclusions? The cause of disagreement, according to the legal model, is that, well, there's just ambiguity in the law. Remember, let me scroll back up here. The language of the applicable law, the intentions, the precedent, right? All of those things are kind of ambiguous. The language is not always perfectly written. Go read the Constitution. It's confusing at points. Congress, not very well known for writing exactly what they want into a law. So there's some ambiguity in these sort of things, the features of a case that each judge is looking at. There's a couple of different types of ambiguity. There's purposeful ambiguity, right? This lines up with what Scalia was talking about with evolutionary clauses in the Constitution. That is, in the Eighth Amendment, cruel and unusual is pretty ambiguous because it's meant to evolve with societal standards. The other type is unintentional ambiguity. This is what I mean when I say Congress is not very good at writing legislation. Part of that comes from it being a deliberative body with 535 total members who all get to propose amendments and things like that if they so wish. But nevertheless, there is ambiguity in the law. One supporting piece of evidence about the fact that there are ambiguities in the law is that, quite simply, if there weren't any ambiguities, there would be an easily and readily identifiable right and wrong answer. And if that's true, the Supreme Court would never have any cases, right? There would be no disagreement in the lower courts, and therefore there would never be anything for the Supreme Court to make a final decision on. They wouldn't need to. Furthermore, if there were cases that had no ambiguity and they did reach the Supreme Court, those cases would probably be unanimous. In fact, the average or the modal decision at the Supreme Court is 9-0. The Supreme Court is fairly unanimous, at least a plurality of the time. And the reason for that is sometimes there are sort of right and wrong answers. Now, that tends to be on these kind of boring cases like tax law or something like that, not the ones we read about in the newspaper. But there is a lot of unanimity when there is no ambiguity. But we also see a lot of disagreement on the court, suggesting that maybe it's a little bit it's something a little bit more than just ambiguity. The legal model suggests that the impact of ambiguity is that pretty much it just provides cover for judges to behave in an ideological manner, or that is to say, to achieve their policy interests, right? So a conservative justice or judge gets to decide conservatively when there's ambiguity, and a liberal gets to decide liberally. But I don't buy that so much, because that would mean all ambiguities in law allow a decision to break down on ideological lines. That's not necessarily true. And in fact, we see that empirically, that not all cases break down so evenly between conservative and liberal. The impact of ambiguity, the legal model would assert, really comes down to a judge's legal training. Okay, that includes things like their personal background, where they went to law school, the type of professors they studied with. Another way to say that is the type of principles of logic that they learned. Did they learn deductive logic or inductive logic? And their legal training, obviously, is the way they interpret the Constitution and statutes. Are they like Scalia? Are they originalist? Are they like Marshall, proponent of a living document? These types of characteristics, according to the legal model, things like legal training, make it so two judges can look at the exact same information and come to two separate conclusions. Okay, so the impact of ambiguity for somebody who supports the legal model suggests, well, they have different legal training, so the ambiguity within there allows their legal training to come to different conclusions. Okay, so let me be a little clear about what I mean when I talk about legal training. It could be as simple as one justice studied at Harvard and the other at Yale. One uses formal logic, the other uses informal logic. One has a family history of being in the legal profession, the other one doesn't. One person was a law professor, the other one wasn't. One person worked in a state court, the other one didn't. All these different types of things are what the legal model points to as causing disagreements. Right? So we have this ambiguity. These sort of different bits of legal training allow one judge to see the world differently than the other one because of ambiguities. Okay. But here's the question: if these legal training differences are so operative, if they're so important, why are there sometimes situations where there are great similarities between two judges and there still are differences? What about ambiguity in legal training interacts when there's similarities to produce different results? So there's a good example of two people who are currently on the Supreme Court. Justice Sonia Sotomayor, who is historically a liberal, and Justice Clarence Thomas, who is historically a conservative. They both have a lot in common. They're both ethnic and racial minorities, the only two presently serving on the court, and only two of only very few to have served on the court. They're both Roman Catholics, so they have a similar religious upbringing and beliefs. They're both once divorced. They're both Yale graduates. They both went to Yale for law school, right? That's a lot of stuff in common if we're talking about only so many things that are influencing the way that somebody looks at the law because of their personal, social, political, and legal background. The legal model would suggest that these two people who have a great deal in common, they just have different legal reasoning. And it's not clear why that should be the case. But I'm going to give you the legal model's sort of defense of why that should be the case. Different legal reasoning just sort of suggests there are different philosophies about the law. There's different approaches as to how to answer legal questions, right? It's not just liberal and conservative. There's different approaches. There are a couple of legal things that a judge might rely on, right? And this goes back to our conversation about the modern philosophies of constitutional interpretation. Some judges think stare decisis is really important. Stare decisis is the idea that previous decisions should stand. So you look at previous court precedent on an issue and you just kind of follow suit. Others, like Scalia, pay a lot of attention to original intent. What did the writers intend? What did the founders intend when they wrote the Constitution? What did they intend when they wrote the Bill of Rights? There's this idea of textualism. What does it actually say on the paper? Did Congress omit something that they usually put into bills like this? And if so, should we take that to mean something? Okay, there's a lot of things here that judges might rely on. And the legal model suggests, well, some judges just pick different things to rely on to help them interpret the Constitution and a statute. The lingering question is, why, if somebody like Sotomayor and Thomas have such similarities, such similar legal training, why would they pick different bits of legal reasoning on which to rely? That's the question that is really difficult to answer. And that is one of the main problems with the legal model. It sort of starts and finishes with the same idea. It's this circular logic. It starts with the idea that legal training matters and ends with the idea that legal training leads to different methods of judicial reasoning, or legal reasoning, rather. Well, if you ask me, those are kind of the same thing. Legal training and your method of legal reasoning are necessarily connected. So the idea that legal training leads to legal reasoning, sure, maybe that's true, but it can't separate out why there are differences among people with great similarities. All these things, right? Precedent, plain meaning, originalism, all that stuff shapes a decision. So different votes are caused by different legal reasoning, but different legal reasoning is caused by the approach to precedent, plain meaning, and all that, right? All of that, it's just you could explain an outcome with any of the things that I just said that are on this slide, and the legal model would say, yeah, that's right. And then you could say, but those things cause each other, and the legal model would say, yeah, that's right. Well, that's a really bad way to define the world. Again, we're trying to find the systematic and the stochastic to define reality. Well, we just jumbled everything up, making it really, really difficult for the legal model to give us sort of the systematic view of the world. Another, on this same, sort of that same token, another huge problem with the legal model is it's just not predictive. I can't tell you, here is Justice Samuel Alito's understanding to legal reasoning and his legal training. Go out and tell me how you think he's going to decide in this case. You might come to the right answer 9 times out of 10, but I'm here to tell you that you could come to that answer 9 times out of 10 because he's conservative. And being conservative aligns with certain types of legal reasoning like originalism, things like that. So the answer that you would give using the legal model wouldn't be nearly as parsimonious as the one we could give using some of the models we're going to talk about in subsequent lectures. So let me say a little bit more about what I mean for the model not being predictive. It's inductive to say Justice X acted in manner Y because of his legal training. That's not falsifiable. We can't prove that incorrect. And as we talked about in the guide to social inquiry, one of the major components of science is being able to falsify something, being able to show it's not true, right? That's if you think back, that's what it means to be sort of the skeptical scientist. You have to show that something's um, the thing that you construct has to be able to be false. Otherwise, you can't prove it false, and that's you can't prove a negative, sort of. We can't study judges in the framework of the legal model. We just can't learn other things about them. Because it's not predictive, we can't show, hey, this is really the way things work. Another problem, again, there's no answer for judges with similarities. We can't figure out why Thomas is the way he is, excuse me, or why Sotomayor is the way she is when they have so much in common. And let's reintroduce implicit biases, right? The legal model assumes mechanical jurisprudence. Mechanical jurisprudence is impossible. We have biases as humans. It's just the way our brains work. It's the way we've sort of evolved to live in societies. But not only that, mechanical jurisprudence improperly assumes judging is an apolitical process. I know that the judiciary is removed from the elected branches and all of that, but I personally think it's a little crazy to expect these 9 people to make decisions about the most important political questions of the day to be apolitical. It's hard to do, if at all possible. And mechanical jurisprudence assumes that they have to do that. I don't know that that's possible, nor do I think that that's prudent necessarily. So again, mechanical jurisprudence is totally impossible. Let's think about implicit biases or the things that affect people without them even knowing. As we're going to talk about in this class later on down the line, things that judges have absolutely no control over, things that nobody has any control over, impact how they vote. A couple of examples here. One, judges with daughters vote in a more feminist fashion on gender issues than those judges that, than judges that only have sons. They don't get to pick what gender their kids are, or whether they have sons and daughters or just daughters. So this is a totally random thing that influences legal decision-making, judicial decision-making, and I'm willing to bet that most judges have no idea that that influences their decision-making. Here's another example. Oldest or only children tend to be more conservative and younger children more liberal, and this includes on judicial outcomes. So if you're the baby of the family, you might vote a certain way because of that. Now, it's not 100% causal, but of course, you have no control over what your birth order is. So for that to have an influence is really significant. We know this because life experiences influence how you perceive information. And we're talking about trying to be these robot judges, right? Mechanical jurisprudence. They're just sort of robots. Information comes in, decision goes out. Well, that's impossible because not everybody perceives information the same way. And of course, these are just a couple of examples of ways or things that can influence how we perceive information. So that's it. That's the legal model. That we sort of have to get that out of the way. That is the sort of classic old school 1950s pre-behavioral revolution and political science way of thinking about how judges behave. And next, we're going to get into more of the attitudinal or sort of ideological approaches or models to the way that judges decide. So I was going to say I'll see you then, but I won't. You'll hear me then.